I'd like to take a moment to recognize a few other people who are in the room. Royce takes a family, a community, some good lawyers, and in Roy's case, you know, just an extremely smart and persistent person with a lot of smarts to get it done. But his sister, Billy Jo, is here, who stood by him and worked hard to make it happen. I'd like her to stand, please. Just. Renee, who continues to stand by him now and every day. So Renee, why don't you just stand for a second? And one of the lawyers toiling hard who actually worked on Roy's original trial and stuck with him and helped him filing all these subsequent motions, trying to figure out how in the world they were going to get an innocent man out of prison. Katie Kurlitz, I'd like to have you stand also. Talk briefly today then about the work of the Innocence Project, about the men and women who have been freed by DNA and what their cases teach us. I mean, Roy's case teaches us a lot, and you've heard about it. I think one of the things he talked about was informants, people who have stories to tell that maybe never happened. The other piece, which I'm not sure he said, although he told the story in great detail and it was beautiful, was that when the original bite mark evidence was looked at by the local dentist, who found that in fact there was a perfect match. There were two things wrong with that. One, of course, there's no such thing as a perfect match in bite mark evidence, so that was a sort of is a funny statement, but gets used in courtrooms all the time. And the other thing is that the district attorney at the time had asked a forensic odontologist with a lot of respect in the state, Lowell Levine, who worked for the state police, to look at the same bite marks, bite prints, and dental molds. And Lowell Levine looked at them and said, in fact, they didn't match Roy, and was told not to bother, didn't need to write a report about that. So there was nothing in the record that indicated that a real expert had actually said there was not a match. Roy didn't have two of his teeth, the top teeth, and there was in fact a perfect bite mark with all teeth present, so hard to see why it was a perfect match, and really incomprehensible to know why the defense didn't find that out until much, much later. The Innocence Project started in 1992. Barry Scheck and Peter Neufeld started as a clinic at Cardozo Law School in New York, and they worked long and hard with students doing almost all of the work. Students actually continue in our clinic. We have 25 Cardozo students who are just finishing their work this week, who really are the workforce on all of these cases. We currently have 260 cases in the office. We work around the country trying to vindicate people's claims of innocence and prove them with DNA. And the students really are the heart and soul of that effort. So for those of you who are thinking about going to law school, there are lots of great clinical programs around the country, whether you're interested in housing law or prosecution or criminal defense. There's probably a clinical experience for you, and I encourage you to do it because there's nothing like real cases, real law, real issues, and real people to make the law feel and be very, very meaningful. Barry and Peter and the students were at Cardozo until about 2004, when they realized the numbers of exonerations were beginning to pick up, and that there was a lot to be done across the country, and it was hard to do it from a small law school clinic. So they decided to create an independent nonprofit organization, and they left the law school in 2004, although, as I say, we're still closely affiliated and the students work on the cases. Currently, we have a staff of 45, including 7 attorneys, almost 25 law students, and a number of other volunteers who work with us. We have 3 basic missions. One is to exonerate men and women across the country. The second is to learn the lessons from their cases, to teach us ways that we should improve the justice system, improve law enforcement, whether it's through legislation or voluntary adoption of better practices. And the third thing is really to get the word out, let people know that the system, while a great system, and with all the principles of fairness, is not a perfect system. And I think Roy's absolutely right that what we have to do is recognize those imperfections and really learn from these cases. I wonder, for instance, if somebody went back and looked at the number of times that dentist testified in cases in Cayuga County and whether or not there's anybody else who's serving time for something that they didn't do. Did someone go back and find the jailhouse informant who gave the corroborating evidence that Roy had called from the jail cell to say that he had actually committed the murder he didn't commit? How many other times was that person used as a witness in a criminal trial? Did anyone go back and look at that? Those are the sorts of lessons we should learn from the individual cases. As I said, today we have 260 active cases from across the country, including 39 clients who are from New York State. There are thousands of others in the pipeline, almost 6,000 people whose cases we are currently evaluating, including almost 1,000 cases from New York prisoners. Last year we heard from 500 New York State prisoners from whom we've never heard. Now, many of those people will never be our clients. Some of them, in fact, don't have claims of innocence. They have claims of kind of technical violations. But even when those letters come in, we look at them carefully because people think the way to get out of prison, the only way, is through proving a constitutional failure. And that certainly is one way to get out of prison. But not everybody tells you, if you're innocent, keep holding on, and that itself is a claim that you can make. And so we try to read very carefully through the letters that come to us to make sure we're not missing anyone. What do we know about the 216 men and women who were exonerated by DNA, who served an average of 12 years for crimes they didn't commit? They come from all over this country. There have been 23 DNA exonerations in New York State alone. 16 of those people were originally sentenced to death, and many, many of them were serving life sentences or 25-year-to-life sentences. As Roy says, if you're not willing to admit guilt to something that you didn't do, the likelihood is that that sentence is for the rest of your natural life. All of them, when they get out, have tremendous difficulties adjusting to life on the outside. I mean, anybody who's been in prison for a long time is going to have a difficulty adjusting to life outside. But I think for the exonerated, for the people who went in innocent, who really could not figure out how they got there, the trauma of that experience and the kind of distrust and disbelief every single day of every single year wears on you in a very profound and special way. I mean, they are resilient. The folks that keep fighting for 12 years, the folks that fight after almost all of them had jury trials, they watched a jury of, their peers convict them. They were sentenced. Most of them appealed to the intermediary courts in their states, if there is one, to the highest court of their state. Many of them filed federal habeas petitions and tried to get the state courts, the federal courts to review the conviction. Many of them filed collateral 440s in New York State or other collateral petitions in other states, and yet they keep on trying. These are people that ultimately believe in the justice system, but the justice system time and time again has failed them. In almost all of the cases, and not all of them, in almost all of the cases, these are hard fought. Roy's case was motion after motion, reasonable request after reasonable request, rational plea after rational plea, and it took a very long time and the miracle of DNA to get him out. We know of these 216 men and women, and we know of hundreds others who've been exonerated across the country by means other than DNA testing, but we know that there also are many people inside who will never be able to prove their innocence. So how many innocent people are there in prison? You can't know. We don't know. I mean, we say if it's even 1%, and that's, maybe you think that's high, maybe you think that's a little low, 1% error rate, not so terrible for most things. 1% of people in prisons in this country today would be 22,000 people in prison serving crimes that they did not commit. We know that DNA is only available in a very small number of crimes. It's really available, when it's available at all, in sexual assault cases, in some murders, often with a sexual assault component, And in some other cases, but probably only in 5 or 10% of the cases that go through the court system, is DNA ever going to be there. So if you were charged and convicted of one of those other 90 or 95% of crimes and you have a claim of innocence, then DNA will not help you. In our cases, when people come to us, we accept their cases. We know that if we could find the DNA evidence, the biology could be tested, and we could answer the question of whether it was our client or someone else who committed the crime. We don't find the evidence in all of those cases, and probably in a quarter of the cases, we have to close the case because the biology is never found. The process takes years, and some are in and others are out by the time they are exonerated. We also can only help the people who write to us. Most of our letters, and we get about 3,000, we hear from 3,000 new people a year, most of the letters come from prisoners, come from their family, and we know that there are people inside who've given up. We know that there are people inside who cannot write, who don't speak English, who have difficulties communicating, and we don't know how to find all of those people. So we know that what we've seen, the 216 exonerations, really is only a part, a tip of the iceberg, a small part, but only a part of what is in fact going on. These 216 cases, however, teach us great lessons, and I think that's what Roy was saying. We have to learn from these. So what have we found? Well, certainly we found that wrongful convictions happen. We found out that eyewitness identification is error-prone. The students saw it this morning when they viewed a demonstration, and I want to make sure I wasn't giving away something that's going to happen later. When the students viewed a demonstration and they picked different people that they thought had snatched the purse that was snatched in the front of the room while they were waiting. There was a difference of opinion among the students, and the person who actually committed the crime was someone entirely different. So eyewitness identification happens, and we find it for 7 lineup. And we're amazed by some of the photo arrays, given the description that a witness gave. There was only one person, in fact, in the array that could possibly match the description of the person. Now, sometimes they get it right anyway. I'm sure most of the time they get it right, but often they're misled by the kinds of information that they gave to, that could have been accounted for in the creation of the lineups.